Uh, Before we broke for votes, the issue from one of my colleagues came up about comparing the administration with the German Stasis. Mr. Siegelman, I'd like you to talk about this inappropriate comparison.
It is an inappropriate and inaccurate comparison. The allegations in the lawsuit brought by Mr. Landry and others is that the federal government coerced social media platforms into censoring content. And there's been vague talk about pressure campaigns and emails between White House officials and social media campaigns. But in federal court, you have to make allegations about what exactly the threats were. And so from the record of the case, here is the Cyber Security Infrastructure and Security Agency, the emails that are cited by Mr. Landry's lawsuit as threats. CISA will not take any action, favorable or unfavorable, towards social media companies based on decisions about how or whether to use this information. CISA neither has nor seeks the ability to remove or edit what information is made available on social media platforms. In light of this absence of a threat in the communications between government officials and social media platforms, the lawsuit turns to other allegations of threatened action. It turns to two. The first is antitrust action against big tech companies, and the second is reform of Section 230. Now, these are implausible bases for threats by the Biden administration against big tech companies. And the reason is because there's a growing bipartisan consensus that big tech companies should be subject to more antitrust enforcement. For example, on May 19, 2022, Congressman Gates was among a group of 4 bipartisan Congress members who introduced legislation that, quote, takes direct aim at Google and Facebook's ad market duopoly. And so Congressman Gates introduced legislation that targeted Facebook and Google for antitrust scrutiny. I don't think that that makes him threatening, in violation of the First Amendment, Google and Facebook, such that their decisions on content moderation are suddenly the responsibility of Congressman Gates. Similarly, on June 11th of 2021, Chairman Jordan introduced the Protect Speech Act, which would have reformed Section 230 to limit or eliminate the immunity that social media platforms have for civil liability for content posted on their platforms. This too was a legislative proposal that is exactly the same type of legislative proposal that this lawsuit and Republicans on this panel are suggesting constitutes a threat. I don't think that Chairman Jordan's introduction of legislation constitutes a threat in violation of the First Amendment. And so once we move past the vague allegations of threatening emails and look to what the lawsuit actually alleges, we see there were no threats, and the challenged coercive action was just legislative proposals that have been made both by Republicans and by Democrats.
Thank you very much. It's useful to note the actions of the members of this committee in that regard. Thank you very much. As we look at what is going on here, our friends across the aisle here continue to claim that there's censorship. Last hearing, I provided extensive information and multiple studies that showed that the social media actually amplifies far-right voices more than left voices, including their false claims about election interference and their efforts to spread COVID disinformation. So if there really is a problem here, it obviously isn't working. The Select Committee on the weaponization of government is really missing the major weapon that was used by the previous administration. President Trump used the federal government, used his position as president and his office of the presidency and others in the administration to promote the big lie that the election was stolen. There is no doubt the January 6th committee proved this beyond a doubt that that's exactly what happens. That is the example of weaponization that this committee should be paying attention to and should be looking for legislation that kind of weaponization by the President of the United States to stop the lawful transfer of power in an election in which there was no proven fraud, that is where we should be spending our time. My time having expired, I yield back.
Gentleman's time has expired. Gentleman from North Carolina, Mr. Bishop, recognized for 5 minutes.
Yield to Mr. Gates.
I'm shocked I have to explain to a law professor that there's an obvious difference between engaging in the legislative process that is open and transparent and subject to our constitutional system, rather than having some skeevy White House staffers trying to threaten social media companies under the auspices of some sort of allowed content moderation. I yield back to the gentleman from North Carolina.
I thank the gentleman. Mr. Sauer, Mr. Seligman's testimony asserts that the federal government didn't threaten or coerce the social media platform. Says the Attorney General's complaint that you're litigating in federal court lacks a reasonable legal and factual basis. He didn't mention that, as I understand it, just last week, the United States District Judge in that case denied the administration's motions to dismiss. Doesn't that denial mean the opposite of what Mr. Seligman testified? Turn on your mic. Is your mic on?
Our federal district judge came to the opposite conclusion.
Yeah. So